Hi, this is the Business Guy. So why do many attorneys tell their clients not to protect their assets from lawsuits? Don't expect your attorney to jump up and down with excitement and tell you to set up an asset protection plan, and I'll tell you why. He'll be too worried about what the judge will think of him on the next 25 cases he brings before that judge. So you need to take action and talk to somebody who specializes in asset protection from lawsuits. In fact, in the over 3 decades I've been in this business, I've trained our staff attorneys, and asset protection is not something they teach in law school. We're the largest asset protection company in the country with tremendously experienced attorneys and consultants on staff. After all, if you have a brain tumor, who are you going to go see? You're going to see a brain surgeon, somebody who specializes in neurology. You're not going to want to go to somebody who specializes in removing bunions from your feet. You want to talk to somebody who has experience taking that dang tumor out of your noggin. And it's the same for attorneys. For asset protection, to protect your house, your cars, your bank account, your investments. I mean, this is your life savings we're talking about here. Consult somebody who specializes in asset protection. By the way, if you appreciate this information, please click like below so YouTube promotes it. My noggin would appreciate it. And if you haven't already, you can also click the subscribe button so that when more videos come out like this one, you'll be up to date right away. So here are some of the reasons attorneys give for not protecting your assets. Number one, he doesn't understand asset protection. And that would be, from my experience, about 99.5% of attorneys. As we said, they don't teach asset protection in law school. They don't teach keeping your money out of the lawyer's pockets 101. In fact, every attorney, except for one who joined our staff at first, had little clue about how asset protection works and what to do. I had to share my 31 years of experience, what we do, how it works, and why. And now we have some of the top asset protection attorneys in the world right here on our staff. So asking any old attorney about asset protection is just about as silly as asking your neighbor who just built a treehouse how to build your next mansion or a skyscraper. Hire a specialist. Number two, he'll be worried about what the judge will think of him on the next 25 or so cases he brings before that particular judge. So that's not a concern about you. That's a concern about his own future career. After all, that attorney loses your case and you get a $5 million judgment. Your attorney is not going to whip out his checkbook and pay it for you. That's going to be on you. One attorney with our firm described it this way: the legal system feeds on taking money from the public and feeding the legal machine. So your money is what keeps the system going. So taking your money away from you and putting it into the hands of your opponent's attorney means that attorney keeps his job. Your attorney keeps his job. There are more cases, demand for more judges, job security for that judge, and the system remains a well-oiled machine with all of the insiders within their little system getting paid. I know I'm getting philosophical here, but that's really what goes on behind the curtain. And that's why you need to get real and have one guy who specializes in fighting your case and another guy who specializes in protecting you in case the first guy loses. An asset protection specialist who doesn't have to worry about seeing that same judge another 25 times. You need an asset protection specialist. So both are needed, and one should not cross over and start telling you not to do things that the specialist knows you need to do. I mean, just my opinion from what I personally observed in my 31 years of experience. Reason number three, that the judge will get mad at you and throw the book at you. Well, first of all, the fact that you have a trust at all usually only comes out in asset discovery during the debtor's exam after the person already has a judgment against you, not before. And even if it does perchance come out beforehand, it rarely has bearings on the merits of the case itself. It should typically not affect whether you win or lose. I remember this one client we set up an asset protection plan for. Surprisingly, he didn't put his assets into it because his attorney said it would make the judge mad. The guy ends up losing $17 million. And at 67 years old, he had to start over in life. Try that on for size. Hey, the judge is just a human being. I think if you're a business owner, you have thick enough skin, you're not going to cry if somebody gets mad at you. Plus, you're 10 times more likely to have your opponent drop the case altogether if they know they're not going to get anything. Which brings us to number 4, the attorney is worried you won't need him anymore. If your assets are protected and your opponent drops the case, poof, there goes your attorney's paycheck. income from you comes to a halt. Now, win or lose, your attorney only gets paid from you if the case keeps going. They say a good attorney can make a case drag on for a couple of years. A great attorney can make it last even longer. Hey, they have to put food on their table just like you do. I mean, think about it, honestly. Do you honestly think that doesn't happen where attorneys make a case drag on longer than they need to just so they can keep getting paid? I mean, honestly. Number 5, they talk about fraudulent conveyance or fraudulent transfer. Same thing. A fraudulent transfer, fraudulent conveyance, now called a voidable transaction, is when somebody transfers or converts a non-exempt asset such as cash, stock, or real estate with the intent to delay or hinder collection by a creditor. Now, the important thing to know is that fraudulent conveyance is a civil remedy only. It is by and large not a crime. As the largest asset protection company in the nation, I have never heard of any client going to jail for it. So a client says, if I do this, they might accuse me of fraudulent transfer. I said, okay, so? And I can almost see the wheels turning. I mean, fraudulent conveyance is like a barking dog in a cage. They wave their bony fingers and say fraudulent transfer. Then when your assets are properly protected, there's nothing they can do in most cases to back it up. The creditor's only remedy, and this has been established by many appellate decisions, is to undo or reverse the fraudulent transfer, which means that the debtor is in the same position he was before he made the transfer. And when your assets are protected, your opponent gets nothing. In fact, I've been in the asset protection business for over 31 years, and as of this video, I believe we have over 85,000 clients, and we've done tens of thousands of corporate and trust filings. And whereas a handful of states have added this to their criminal code, it typically deals with a very specific intent. Because of fraudulent transfer laws, many domestic or U.S.-based asset protection trusts don't tend to work very well because a judge can easily undo the transfer, whereas an offshore trust is outside of the local court's jurisdiction, and your local courts do not have the right to issue court orders to foreign trustees. So the term fraudulent conveyance sounds scarier than it really is. It's simply a civil matter, not typically a criminal one. So in my experience, it's usually better to do it and then make them fight for it than it is to just roll over like a dead dog and leave the assets lying out in the open. Put up a fight. Make them work harder to take your assets than you had to work for them to earn them in the first place. Fraudulent transfer laws are statutory, meaning they are written in the law books, and our local fraudulent transfer laws do not provide for criminal remedies, and they do not give the ability to assess additional damages or fees against the debtor. Now, there are certain drawbacks to attempting fraudulent conveyances that involve friends or family members. These people will often end up in a fraudulent transfer lawsuit. So what a person ends up doing is dragging loved ones into their problem. That is, people who've tried to help you by receiving your assets get stuck with huge legal bills, and that will not be a happy conversation on Thanksgiving Day. So don't transfer assets to friends or loved ones. Don't transfer to your spouse. Dragging your wife into a lawsuit doesn't boost the romance. Instead, set up your own asset protection trust. So those are the top 5 reasons why an attorney who does not specialize in asset protection will tell you not to protect your assets from lawsuits. If you need help, please reach out to us at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Please like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy. See you next time.